All right, the Senate Committee on General Laws will come to order. Mr. Secretary, please call the roll. All right, a quorum being present, I make a motion that we go into executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any contrary, say no. The ayes appear to have it. The ayes do have it. We're in executive session. The first bill here, I make a motion that the Senate Committee vote do pass House Bill 2108. If everyone will recall, this is Representative Griffith's land conveyance bill. There is a Senate Committee substitute that's been distributed, and I move for its adoption. It's been seconded. All those in favor, please. Oh, hold on one second. We'll explain it first. I think you're going to love it. This committee substitute only differs from the perfected House Committee substitute by modifying the property description located in Cole County to be conveyed to the city of Jefferson, so it is a technical amendment. Any discussion on the motion to adopt the Senate Committee substitute? Oh, okay. All right, hearing no discussion, all those in favor of adopting Senate Committee substitute, please signify by saying aye. Any to the contrary? The ayes appear to have it. The ayes do have it. You have adopted the Senate Committee substitute. I now make a motion that the committee vote do pass Senate Committee substitute for House Committee substitute for House Bill 2108. Any discussion? And do I have a second? It's been seconded. Any discussion? Hearing none, Mr. Secretary, please call the roll.
Chairman Trent.
Aye.
Senators Gregory.
By your vote of 5 aye and 0 no, you have voted do pass Senate Committee substitute, House Committee substitute, House Bill 2108. I now make a motion that the committee vote do pass consent Senate Committee substitute for House Committee substitute for House Bill 2108. Any discussion? And I'll remind the committee this has to be a unanimous vote if we want to send out consent. So if anyone has any concerns about doing that, please.
Who's the Senate handler?
Senator Bernskoetter, I believe, will be the handler.
I'm okay with it. Good choice.
No, there appears to be mixed opinion here, but I'm relatively certain in jest.
In jest.
Any discussion on the motion before the committee? Hearing none, Mr. Secretary, please call the roll.
Chairman Trent.
By your vote of 5 ayes and 0 noes, you have voted do pass consent Senate Committee substitute for House Committee substitute for House Bill 2108. Next, I make a motion that the Senate Committee vote do pass House Bill 1839. Do I have a second? It's been seconded. If everyone will recall, this is Representative Gallick's age verification bill. Discussion on the motion. Hearing none. I renew my motion that committee vote do pass House Bill 1839. Mr. Secretary, please call the roll. By your vote of 5 aye and 0 no, you have voted do pass House Bill 1839. Next, make a motion that we bring before the committee House Bill 2375. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any to the contrary? The ayes appear to have it. The ayes do have it. Next, make a motion that the committee vote do pass House Bill 2375. There is a committee substitute that has been distributed, and I move for its adoption. So this Senate Committee substitute, if adopted, would add the workers' compensation fee schedule, which the committee has also heard, to this modest legislative package.
2375, House Bill. Oh,
.03C is the committee sub that we are looking at here. Any discussion on the motion to adopt Senate committee substitute? Hearing none, all those in favor of adopting Senate committee substitute, please signify by saying aye. Aye. Any to the contrary? The ayes appear to have it. The ayes do have it. You have adopted the Senate committee substitute. I now make a motion that the committee vote do pass Senate committee substitute for House committee substitute for House Bill 2375. Do I have a second? It's been seconded. Any discussion on the motion? Hearing none. Mr. Secretary, please call the roll.
Chairman Trent,
Aye. By your vote of 3 aye and 2 no, you have voted do pass Senate committee substitute for House committee substitute for House Bill 2375. I next make a motion that we bring before the committee Senate Bill 1562. Do I have a second?
second.
It's been seconded. All those in favor, please signify by saying aye. Any contrary? The ayes appear to have it. The ayes do have it. The bill is for the committee. I make a motion that the Senate committee vote do pass Senate Bill 1562. If everyone will recall, this is Senator Lewis's mental health hotline bill. I think there's probably still some work to be done on this bill, but want to see it have an opportunity to get out of committee. Any discussion on the motion?
Mr. Chairman,
Yes, Senator Coleman.
I just want to concur. I think that there is more work that needs to be done on this. I'm happy to help keep it moving, but I haven't checked the vote. I don't know if it's close or not. So I'm happy to vote for it to get it out of committee, but I'm not quite there yet on the floor.
Thank you. Further discussion? Yes, Senator.
I appreciate the intent of the bill and would like to continue to also to see it go along, but I will be voting no until we see some of the changes. So, thank you.
Very good. Further discussion on the motion? Hearing none. Mr. Secretary, please call the roll.
Chairman Trent,
By your vote of 4 aye and 1 no, you have voted do pass Senate Bill 1562. Next, make a motion that we leave executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Aye. Any to the contrary? The ayes appear to have it. The ayes do have it. We are out of executive session. And we will begin with public hearing for Senate Bill 1602. Senator Gregory.
I was like, oh my God.
We don't have to.
I could present it. Yeah, just hand us the packet.
And please proceed when ready, Senator.
Thank you, Mr. Chair, members of the committee. Sorry for the tardiness to coming down here. I'm trying to recover from winning third place in the softball tournament last night. Or as the trophy
Senator,
says.
isn't that called losing?
Well, some could view it as that, but the trophy does say first place consolation, so at least we got first place somewhere. Happy to present before you today Senate Bill 1602. This bill has been filed in response to the rapidly changing healthcare landscape in Missouri and the growing crisis facing hospitals across our state, specifically rural hospitals. Over the past decade, more than 20 hospitals have closed across the state of Missouri. 10 of those were rural hospitals, 4 in central Missouri in just the past 6 years. Nearly half of Missouri's remaining rural hospitals are now financially vulnerable, and many are actively seeking partners to maintain access to care. One specifically in my district where I come from, Fitzgibbon Hospital, they've been in the news lately for reduced bond ratings, and it's no secret around home that they are struggling to continue to make ends meet. While not every inpatient facility can be sustained in its current form, what we have here is a responsible way to act thoughtfully and strategically to preserve access to care wherever possible. This is why we're proposing enabling legislation for MU Healthcare as the state's only academic safety net system affiliated with the land-grant university. MU Healthcare is uniquely positioned to partner with providers across its 25-county service area, which is where 85% of its patients currently reside, though they do see patients from all counties across the state of Missouri. Some may argue this legislation limits choice, but when a hospital in central Missouri struggles financially, communities typically face three realities. You can hopefully partner with Mizzou Healthcare, be acquired by private equity, or close altogether. The last of which is an option that is not going to be the best option at all of closing altogether, because the more they close down, the further you are from having access to care at critical moments. I just think about an incident that happened this weekend. Luckily, the hospital in Carrollton is still there. Unfortunately, wasn't able to help out a local farmer that he made it there in time, but died of a massive heart attack in the waiting room. And you think about those critical minutes of, had maybe they've gotten there 5 minutes sooner, that the doctors at that emergency room would have been able to do something for them. But what I start to think about in the situation before us today is, if Carrollton hadn't been there because of this, and there was no hospital anywhere closer, that there was no way he would have even had a chance of making it. We have seen private equity enter markets like Fulton, New Mexico, only to then close facilities without warning and leaving patients without access to care and staff without jobs. This legislation does not give MU Healthcare exclusive authority. It simply ensures they can respond quickly and responsibly when they are the partner of choice. And ultimately, this bill is about protecting patients, supporting communities, and preserving access to care across Missouri. And when we talk about supporting communities, oftentimes the hospital is like the anchor for the workforce in any particular rural community. I know in Marshall, they've got well over 400 employees, and it's been the backbone of the community. They've got a cancer center, so people are able to get cancer treatment right there in Marshall instead of having to travel to Columbia or Kansas City. There's great rideshare agreements set up, and it's truly an anchor to the community. So with that, Mr. Chair, I'm happy to take any questions.
Thank you for that presentation. Questions for the bill sponsor from the committee? Hearing none. Thank you again. First witness in support.
Good afternoon, and thank you for the opportunity to share some remarks before the committee. My name is Rick Ransom. I serve as the Chief Executive Officer for MU Healthcare, and I want to thank Senator Gregory for being one of the co-sponsors of this bill. During my brief time, I want to talk briefly about some of the same facts that Senator Gregory described, but I want to describe them a little bit differently. So over that 6-year period of hospital closures, MU Healthcare went from being one of 17 hospital system operators in that 25-county area to one of 13. So part of why we have grown over the last 10 years or so then has been influenced by hospital closures. Over that same period of time, there is less choice. So for the 800,000 or so Missourians that live in that 25-county area, they have fewer hospitals to choose from. Access is also been impacted. People have to drive further for care. A big part of our growth then has been because of pressures on hospitals in rural Missouri. Costs have increased. Here in this room, who hasn't experienced increased healthcare costs? And I think that's true for all segments of the industry. Hospital system providers, one of the reasons that 4 hospitals have closed over that period of time is because it costs more to be in the business. MU Healthcare, as a public academic health system, the largest portion of our payers are governmental, Medicare and Medicaid. And as you think about cost impact, it is important to understand that for Medicare and Medicaid, for their traditional products, nobody negotiates with them. Medicare and Medicaid set the rates, and then the healthcare providers accept those rates and work within them. Insurers also have been impacted, but my position is that for the large the two largest commercial payers in the state and in central Missouri, the impact hadn't been quite as dire. I have not seen any reports of the struggling health insurers and how many of those have closed or stopped offering business in central Missouri over the last 6 years. So as you look at choice, access, cost increases, for reasons that have nothing to do with a legislative monopoly, there's less choice in central Missouri. There are challenges with access, and costs have increased. Opponents of this bill would have you believe that allowing the state's public academic health system to more effectively work with hospitals or providers that are in distress, that somehow magically this bill is going to make all of those things worse. The reality for people that have been living, working, and being cared for in central Missouri is that there are challenges in all of those domains, and that this bill represents an opportunity to remove one barrier. It provides no financial incentives. There is no taxpayer support that is required. MU Healthcare will continue to be self-sustaining and working with organizations that are interested in working with us. This is a complicated issue, and this legislation represents, I think, a thoughtful, cost-effective way for the state of Missouri, for this body to show their support for helping the state's public academic health system be able to better support communities in need over the years to come. Thank you for the opportunity to testify and for your consideration of this legislation.
Thank you for that testimony. Questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses and support.
Hello, Senate Committee. I'm Bill Hellebush. I'm the CEO of Herman Area District Hospital. I believe I'm the closest critical access hospital to MU Healthcare, and when I hear opposition to this bill, I think people oftentimes are talking about me or people like me for fear of competition, and what if MU comes into a community like ours and outcompetes us? And I guess I just see it differently. I think to have that viewpoint would be the viewpoint that myself or my peers, that we could do it alone. And I'll just tell you right now, I won't go through all the struggles, but Rick mentioned them. Because of all those struggles, there is no way that we can do them alone. And honestly, we're constantly looking for good partners. And I think that's very much in line with what the rural health transformation work lays out for us ahead is partnering together. Specifically, how we've partnered with MU over the last couple of years. I've been at Herman Area District Hospital for 3 years. MU started there just before I did in an agreement that allowed them to provide 24/7 emergency services to our hospital. So they are the providers in our ER. Since we've had that partnership, we've experienced a lot of different things to our ER, one of which being a mass casualty event in which 34 patients were injured in a trolley accident, the preponderance of which came in through our ER. Of course, we had MU provider there. We had several other MU providers that actually joined them there that honestly, without that level of support, I'm not sure how we would have treated and taken care of all those patients that came through our doors that day. Also in that time period, we've had several patients come in full cardiac arrest, actually 4 in the last 12 months, who were stabilized at our hospital with MU services, and then they were taken to an appropriate accredited STEMI center. But they arrived at our hospital for stabilization and revitalization initially. We also had an officer-involved shooting during that time, one of which, unfortunately, we were not able to revive, but one we did, and we did all this with MU. The other thing that I've seen, and actually it was just yesterday, is MU is helping us invest in things in our community to make the care better and keep it closer local to home. We had an MU van, it's like an RV that actually came, and it teaches all of our providers at our hospital about certain emergency care and practices to help improve our quality at the hospital, which is really great. We wouldn't have access to that otherwise. So I guess what it boils down to is I don't see it as a threatening thing to what we do. In fact, I think Rick Ransom would be crazy, or MU would be crazy. I don't think they are, to want to outcompete a hospital like ours because it would close beds. And there's not a hospital administrator in Missouri or probably in the U.S. that wants to see the closure of beds because it's untenable. Our system can't take it right now. So I see it as partnership, and that's, in my position, that's what I need right now. I need more than just options. I need partnerships, and I welcome the partnership available through MU.
Questions for this witness? Hearing none. Thank you for being here. Next witness in support. And we'll remind witnesses that we do have a timer and appreciate everyone being able to complete their thoughts, but we do have a lot of material to get through in about 30 minutes. In which
Mr. Chairman, committee members, Tom Rackers, testify in support of this legislation. A year and a half ago, Capital Region Medical Center here in Jefferson City was ready to close. They were given about 30 days. The CEO told me, he said, 30 days, it's over. MU came in and bought Capital Region. Right now, it's at sometimes there's a 6-hour wait in the emergency room. So people are catching on, they're calling an ambulance. And the ambulance, when you arrive in the ambulance, you get and take care of it right away. How long is that going to last? I mean, people catch on to that. Pretty soon you won't be able to get an ambulance in Jefferson City. I'm testifying for you all too. Half of the year you live here. If you had an emergency, you need Capital Region. And hopefully you can support this legislation. Thank you.
Thank you for that testimony. Sir, could you please state again who you represent today?
Myself.
Oh, and could you restate your name for the record?
Tom Rackers, I'm sorry.
Oh, thank you.
Thank you.
We just want to make sure we get everyone recorded. Next witness in support.
Good afternoon, Mr. Chairman. Mike Sutherland with the Missouri Electric Cooperatives, and we're here to testify in support of Senate Bill 1602. The Missouri Electric Cooperatives represent rural communities across 80% of the geographic area of Missouri, and we support anything that will give options for our rural communities to thrive and have. And this option looks like it would help some of those hospitals stay open and help those communities.
Thank you for that testimony. Questions for this witness? Hearing none. Next witness in support.
Mr. Chairman, members committee, Ben Travelis with the Missouri Soybean Association would like to go on record in support of this legislation. Access to rural health care is one of the top issues that we hear from our farmer members, and so for that reason we would like to go on record in support of this legislation. Appreciate Senator Gregory bringing it forward.
Thank you for that testimony. Questions for this witness? Hearing none. Next witness in support. Seeing none, first witness in opposition.
Mr. Chairman, members of the committee, Jorgen Schlemm on behalf of Jeff City Medical Group. We are a locally owned and operated medical group here in Jefferson City. We 100% that was a quick 2 minutes. We 100% applaud MU for wanting to take healthcare to the rural areas and absolutely support that. However, this bill takes it one step further and actually doesn't just, within the 25 counties that it includes, 2 of those counties, Boone County and Cole County, currently have multiple hospital systems operating in them. And we believe it is critical for multiple hospital systems to thrive. It makes it better for local providers, and it's good for local access and prices. I'm not sure I'd be here in opposition today if those 2 counties, Cole and Boone, were removed from the bill, because we absolutely believe that Fulton and Marshall and Mexico and Herman, all of those systems either have 0 or 1 hospital, and MU partnering or opening a hospital in those communities sounds great, and I'm not sure they need legislation to go do that today. But I believe that the legislation exempting them from antitrust is somewhat more narrowly tailored to Cole and Boone County, with the other 23 counties somewhat as window dressing to try to get the exemption from antitrust for those 2 counties, and we would ask that those 2 counties be removed.
Questions for this witness? Hearing none. Thank you again for being here. For the witnesses in opposition.
I'm Andrew Lovewell. I'm the Chief Executive Officer for Columbia Orthopedic Group, testifying in opposition for this bill. Just like Mr. Schlemeyer said, well, we would probably not be here as well in opposition if Boone and Cole County were taken out of the bill. Just recently, less than a year ago, the university went out of network with Blue Cross, the same insurance provider the state employees have. What's to stop that when they have every county hospital in the region? Nothing. As Mr. Schlemeyer said, they could do this and execute this without the antitrust bill at all in these counties. That's why we are in opposition of this bill.
Questions for this witness? Hearing none. Thank you again for being here. Further witnesses in opposition?
Thank you, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. I submitted my opposition to this bill on the Senate online portal. Did you receive it? Okay, thank you. I appreciate that. Back on February 12th of this year, I highly opposed at the House Rural Issues Committee a similar companion bill, HB 3170, for the following reasons. Currently, Missouri has 58 rural hospitals that serve Missouri. These 25 counties are in the mid-region, and the number one priority is that we want to make sure that the University of Missouri does not create an antitrust or a monopoly of medical care in the hospitals. The fiscal note is very concerning on our state budget and state General Assembly appropriations. If Mizzou starts to grab up a number of hospitals, it's going to be a huge fiscal responsibility and additional appropriations that's going to be asked for on the university's behalf. And so that's very concerning and hasn't come up in any of the discussions or any of the debate. The two past testifiers brought up the immunity, and that's very concerning to me. The immunity from liability with regards to the 25 counties for antitrust issues should be taken out of this bill. MU is no different than a private organization, or because, to be honest, they've put themselves as a front leader and a profitable leader out there, and they should be under the federal and state antitrust laws like anybody else. Other medical liability within the 25 counties needs to be brought up and debated. This immunity for liability opens up the door, in my opinion, for 100% immunity. There's another bill marching through the Senate and the General Assembly that would limit municipal hospitals and county hospital districts to $1 million on a top liability. And I'll tell you what, if a doctor or medical personnel takes the wrong leg or the wrong limb or the wrong organ of a Missourian, they need to be held accountable and responsible. And it's probably going to be a lot more than $1 million that we value a Missourian's life. And for those reasons, there's no way I can support this bill. And I'm highly opposed to SB 1602 and HB 3170. Thank you, Mr. Chairman.
Questions for this witness? Hearing none. Thank you again for being here. Next witness in support, opposition.
Good afternoon. My name is Lisa Leathers, and I am the president of the Missouri ASC Association. I'm here today representing our members across the state to testify in opposition to this Senate bill. Also as a local, and I do respect and have worked at Herman Area District Hospital and MU Healthcare, and commend you for the great services that you provide for our community, which is, I think, the most important thing that we're here to discuss. We oppose this bill for two primary reasons. First, history has shown that the people we care about suffer when a policy is rapidly changed and the local infrastructure is not prepared to meet it. A clear illustration of this risk was the transition of behavioral health services in the 1980s. A policy shift was made to move care away from large state institutions, but the community-based infrastructure wasn't yet prepared to absorb that volume. And in the years it took for practice to catch up to policy, a massive gap in care was created, and people suffered in the interim. Now, we have heard that this legislation proves to kind of prevent that gap from occurring. But what's potentially a side effect that hasn't been considered is what this means for surgery centers. The healthcare landscape in Missouri is similarly complex to what we saw in behavioral health, and it's often tethered to the hospital system in significant ways. For scope, in Missouri, we have 118 ASCs, with at least 6 in central Missouri. ASCs are highly specialized, high quality, and efficient. In Missouri alone, ASCs save Medicare $81 million per year through lean modeling and reduced reimbursement rates compared to hospitals. Just between COG and JCMG ASCs combined, we provide jobs to 150 people. We will perform 22,000 surgical procedures this year alone, and in cooperation with over 50 different physicians. So it's a huge portion of the ecosystem in central Missouri. Missouri ASC regulations require that every surgery center is either to have a standing transfer agreement with a nearby hospital or for each physician operating in that center to have admitting privileges. This is a licensure requirement in Missouri. And failure to meet one of these pathways results in a license suspension or revocation. However, the regulations do not require a hospital to honor a transfer agreement or grant privileges. So if this bill passes, specifically with its provisions for antitrust immunity, surgery centers in mid-Missouri would become entirely dependent upon the goodwill of a single entity, MU Healthcare, to keep their doors open. Without a transfer agreement, these sites of service would vanish overnight. This is a primary example of how a tremendous gap in coverage can be created when practice is not prepared to meet policy. Secondly, we must consider, as already pointed out, the necessity of market diversification. When one of the region's health systems and a major payer reached an impasse in negotiations last year, it left thousands of mid-Missourians out of network. This forced a scramble for alternative access to care. Our practice and others outside that specific network served as a critical relief valve during that time. These unpredictable external factors, such as challenging payer negotiations, are ramping up across the country. Diversification in service delivery options creates a necessary relief valve for our community. If the future landscape of healthcare delivery in mid-Missouri is to be dominated by one hospital system, we must ensure first that all contingencies are considered and that practice matches policy. We must ensure that your constituents are not left destitute in a gap of coverage. And for these reasons, we ask that you vote no on Senate Bill 1602. Thank you, and I'm happy to answer questions.
Questions? Hearing none. Thank you again for being here. Next witness in opposition.
Good afternoon, Mr. Chairman. Hampton Williams with the Missouri Insurance Coalition, here in opposition of the bill. This bill addresses state action immunity. It is different from its House companion in that this legislation seeks to expand immunity from antitrust laws not only to the University of Missouri, but also to entities that it would be contracting with. I'll submit an article on these type of arrangements and issues on the implementation of them, which identify that within the immediate term of these type of exemptions for federal antitrust laws, that there are anywhere between 20% increases within several years, 25% increases to costs of to consumers, insurers, and payers. So there are cost concerns on this type of market consolidation and the upward pressure it can have on those marketplaces. The other issue on how the bill is drafted, for state action immunity, there has to be a clear articulation of the immunity itself, and then there actually has to be some type of active oversight of the entities that receive this immunity, and whether or not non-parties, entities that are not state entities or affiliated with the university, would qualify for that. I think that's an open question, something that needs to be considered. Also, there was an article posted last week, Fifth Circuit opinion on whether or not the University of Texas medical system qualified for sovereign immunity under the 11th Amendment. And there was a whole test which talked about how you would determine whether or not there was adequate state oversight of that entity, and the determination was that no, there was not. And again, whether or not that type of standard is going to be applied not only to the University of Missouri, but to these other third parties, I think there is a question as to how this could be implemented, even were this to pass. So I will submit these articles along with my testimony, with my sheet for the committee's consideration.
Questions for this witness? Hearing none. Next witness in opposition.
Mr. Chair and members of the committee, Michael Henderson on behalf of the Missouri Cancer Associates, going on record in opposition to this legislation. We are an independent, community-based, multi-specialty practice with locations in Columbia, Kirksville, and Marshall. obviously concerned that consolidation can lead, even inadvertently, to higher healthcare costs and less choices for patients. For those reasons, the reasons set forth in a letter I'm submitting to the committee, as well as those already stated, we oppose the bill.
Questions for this witness? Hearing none.
Thank you.
Next witness in opposition. Seeing none, any witnesses here testify for informational purposes only? Senator, would you like to conclude?
Thank you for the hearing. I think what we've been doing currently to try and help rural hospitals hasn't worked. They are continuing to close. They're continuing to financially struggle. I'm proud that my university, my alma mater, has come up with a solution to try and keep some of these rural hospitals open, to try and keep access to care for these patients in these communities. So with that, thank you for the hearing and look forward to moving this bill forward. Thank you.
Thank you. That will conclude the public hearing on Senate Bill 1602. We will next proceed with public hearing for House Committee Substitute House Bill 2105. Representative, please proceed when ready.
Thank you, Chairman, members of the committee. My name is State Representative David Casteel from the 97th District, and today I'm proposing a straightforward pro-transparency bill that clarifies how landlords may fairly allocate water and sewer costs to tenants in multi-unit properties without turning those landlords into regulated utilities. House Bill 2105 does three main things. First, explicitly allows public property owners to either install a separate meter for each unit and bill tenants based on their actual metered water and sewer usage, or use a clear mathematical formula to allocate the total water and sewer bill among all the tenants, including the common usage. This is called RUBS. It's a ratio utility billing system. It's nationally recognized and utilized all over the country. Second, the bill builds strong disclosure and consumer protection requirements. If a landlord uses individual meters, each tenant's bill must show their usage for that period and beginning and ending meter readings and the dates those readings were taken. If the landlord instead uses the formula must be clearly described in writing and provided to the prospective tenants before the lease begins, so that tenants know up front what their rate will be and what their cost will be, or how their cost will be calculated. Third, House Bill 2105 caps what can be passed through and narrowly defines the fees that may be charged. The total amount billed to all tenants for water and sewer cannot exceed what the utility charges the owner for that property, excluding taxes and surcharges. So there's no markup of the commodity itself. The bill allows for reasonable administrative fees, mostly just used to cover the third-party expense of covering the meter disclosures or the meter readings. The bill does not allow and late fees. It also allows for late fees, but only if those charges are disclosed before the lease, and in the case of late fees, they're treated as rent under existing landlord-tenant law. It also makes clear that either the landlord or third-party billing company can perform this billing, and to do so does not make them a public utility subject to Public Service Commission regulation. So in practical terms, House Bill 2105 encourages conservation and fairness. Tenants who use more water pay more. Those who use less pay less, and the total calculated can never exceed the actual amount billed by the utility. It gives property owners clear statutory authority and guardrails while giving tenants transparency, predictability, and protection against overbilling. The bill passed General Laws Committee in the House 14-0, passed Legislative Rules 11-1, passed out of the House Chamber 139-9 with 7 members voting present, and I respectfully ask that you support House Bill 2105.
Questions for the bill sponsor?
I have a question.
Proceed.
I understand what you're trying to do here, but I am concerned that a renter could pay their bill to the landlord, but if the landlord never pays the water company, then there could be a shutoff. So I've got an amendment already drafted up that would just say that a public utility shall not interrupt or stop service if the owner or operator doesn't pay the bill, basically. So is that something you would
Yeah,
consider?
that sounds good to me. The situation presented itself when I think only one public water district decided to interpret the law as requiring master meters to be installed in every single unit.
Which is so expensive.
It raised the cost of 100 units by $500,000.
Yeah.
So that's what we're trying to avoid with housing being a crisis and access to affordable and workforce housing. We don't want, the last thing we want to do is raise the cost.
Right.
So yeah, I don't see how that would
Yeah,
present a
and I
problem.
think probably like in any profession, like the vast majority of people are good actors and they're going to take that money and pay the water company. But I just want to make sure that people aren't caught in a bind where they've paid the landlord and that money never makes it to the water
I'm
company.
happy with that amendment. We might add that because the utilities will probably respond
Yeah.
differently, but maybe if we gave them the access to the tenants just to provide the disclosure 30 days in advance or 60 days in advance to let the tenants who have been paying their bill know that their landlord has not paid their bill.
Yeah.
That way it puts the community on alert.
Yeah, 'cause
but at
how
the
would they
same
even
time,
know?
we can't allow the bill not to be paid by the owner.
Yeah.
Because then a lien will go on the property and further things. So
Yeah,
I
I'm
mean,
happy to work the details out with you, so
Yes.
thanks.
Thank you.
Further questions for bill sponsor? Hearing none. First witness in support.
Good afternoon, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. I submitted my online testimony on the Senate portal in favor. A few months ago, I testified in the House General Laws Committee in respect to House Bill 2105. And I'll tell you what, the sponsor is correct. How it came about was Public Supply Water District Number 2 of St. Charles and Warren counties. There was a Columbia firm who built with state and federal funding and low interest loans senior housing, and they were taking advantage of senior citizens in O'Fallon, Missouri, at the corner of Mexico and Bryan Road. And what they were doing is they didn't have any water usage, and they were taking the bill and divvying it up, and then they were adding on about approximately 30% surcharge on to senior citizens on fixed incomes or disabled Missourians, and it was totally ludicrous. So the Public Water Supply District, after this came to my attention, I approached the Water District and said, this is not correct. This is deception, this is fraud, this is taking advantage of our disabled and senior citizens in O'Fallon and St. Charles County. And so the Water Board cracked down and sent a letter to a father-son who have made millions off of tax credits from this legislature and who have received millions upon millions of dollars of Missouri Finance Board funding, Missouri Housing Finance Authority funding to construct senior housing around St. Charles County. These fees were out of control, taking advantage of Missourians, and it had to come under some type of control. So I applaud the bill sponsor, and I'll wrap it up, Mr. Chairman, for sponsoring House Bill 2105. It keeps safeguards and civility and actual charges without any markups, and I am in whole support of HB 2105 for the reasons that I've explained. Thank you, Mr. Chairman.
Questions for the witness? Hearing none. Further witnesses in support?
Hi, I am Jana Millard. I'm here with the Missouri Apartment Association, Mid-Missouri Apartment Association, and then I manage an apartment complex here in town that utilizes the RUB system, and we're here in support of the bill.
Thank you for that brief testimony. Any questions for this witness?
You
Hearing
can set
none.
the alarm off if you need to, but.
Yes, excellent. Further witnesses in support?
My name is Shauna Lipp, and I am here also with the St. Louis Apartment Association, along with 2B Residential. We operate apartments for landlords, and I see both on the construction side as getting built what the cost is for our builders, and then after we start operating it, I've seen the cost of how expensive it is to keep these maintained with the residents. I did some comparisons, and we've got a property that was built without the individual meters and then one that has them. And I was looking at our financials trying to explain this huge difference. It's like $30,000 a year. I have a property that's smaller paying in some of these fees than my one that had just like your basic water meter going into the property. I know you had a question about, you know, wanting to make sure that the tenants aren't paying more than what, or the bills are getting paid and not shut off. How all of the properties work that have like the RUB systems, it's in the rears. So when someone moves in, they don't even see a water bill because we have to wait for that bill to be paid. And then we what's called conservice typically will then get the water bill and say, here's your assumption, and then charge the residents. So they should always have the water bill, sewer bill, whatever's paid first, and then their tenants will see the bill. So again, I am here for this bill. So if you have any questions, let me know.
Questions for this witness? Hearing none. Next witness in support. Seeing none. Witnesses in opposition. Seeing none. Witnesses here for informational purposes only. Seeing none. That will conclude. Representative, do you have any closing remarks?
I'd just like to thank the committee. This is about economic development, providing opportunity for those who can't buy a home, afford interest rates, et cetera. And we just want to make it clear and clarify that you know, it's one of these two options. Simple bill. Thank you for your support.
Thank you. That will conclude the public testimony, public hearing of House Committee Substitute House Bill 2105. Next, we'll proceed to public hearing for House Bill 2146. Representative Kalberloh, please proceed when ready.
Thank you, Mr. Chairman and committee, for hearing House Bill 2146. And you may have heard this, Senator Crawford has a companion bill just like this. And
yes.
It's the exact same language, I believe, just trying to, we've heard about hospitals today, and this is another one on hospitals, and talking about investments, and most of those rural hospitals don't have investments, but if they do, they'd like to make as much as they possibly could on those investments. And so we're trying, and there was a bill 2 years ago carried by Representative Peters that was for county hospitals doing the exact same thing, same language as this, and we just didn't catch it that it didn't include district hospitals, which is what I have in my district, and there's several around the state that are in district hospitals, and it didn't apply to that, so we're just trying to apply it to that, to where they can invest up to from 25 to up to 50%, and then they can use something besides a passbook savings that earns hardly nothing and can invest it in things that will create them a little bit more interest income. So if any questions, I'll be happy to try to answer.
Thank you for that presentation. Questions for the bill sponsor? Hearing none. First witness in support.
Good afternoon, members of the committee. My name is Alex Tuttle, here on behalf of Golden Valley Memorial Hospital. We'd like to go on record in support of the bill. Not much to add from what Representative already said, so happy to take any questions.
Questions for this witness? Hearing none. Next witness in support. Seeing none. Next witness in opposition.
Thank you, Mr. Chairman, members of the committee. My name is Arne C. A.C. Dienhoff, State Public Advocate. I submitted my opposition to the bill, House Bill 2406, on the Senate portal. I also testified in Senator Crawford's bill. I forget the bill number, but I testified against that bill also. I feel that investments should be under the local governance and control of the Board of Trustees or Board of Directors with limited availability, and to protect residents of a municipal district or a municipal corporation that's operating a hospital, or a hospital district, or a county hospital district. There's many variations under the hospital state statute that a hospital can be formed as a entity or a political subdivision with a tax levy on personal and real estate taxes to the people who live within that jurisdiction. 50% of investments, in my opinion, is a huge liability. If they're going to be investing in stocks or bonds or other issues, I think that's way too much money to put that out there in the limb for somebody who may not be conservative, who may not want to diversify, but be liberal in their investment opportunities. This is not a private entity. This is not a private risk. These are taxpayer dollars, taxpayer monies that are being raised from a property and personal property tax levy, and therefore I think we need to limit the amount that can be invested in available investments. For those reasons, I do not support the Senate bill or House Bill 2406, and that's my testimony, Mr. Chairman.
Questions for this witness? Hearing none. Further witnesses in opposition? Seeing none, any witnesses here for informational purposes only? Seeing none, Representative, do you have any closing remarks?
I don't just appreciate you having the hearing. Appreciate it. Thank you.
Thank you, Representative. That will conclude the public hearing on House Bill 2146. We will next go to public hearing on Senate Bill 1053, and I will turn the committee over to the Vice Chairman.
Public hearing on Senate Bill 1053, presented by Senator Trent. Please proceed when you're ready. Take all the time you want. Not like we have anything to do on the floor this afternoon.
Oh, thank you, Mr. Chairman. We'll do my best here. So, Curtis Trent, representing Senate District 20. We do have before us a simple bill. That does not necessarily mean non-controversial, but I think it accomplishes a very simple change. Under the Missouri Human Rights Act, currently, any prevailing party in civil action brought pursuant to that chapter is awarded court costs and reasonable attorney fees. This would limit that to only cases not involving a public employer. The reason for this is that we've seen a number of cases over the years where attorney fees are exceeding the underlying judgment that's ultimately awarded in a case. And so it's kind of created a perverse incentive for cases to be drawn on far longer than they need to be. And this really makes no sense from a public policy viewpoint where you're expending taxpayer dollars in this enterprise. So that is the reason, the purpose for the bill. Be happy to answer any questions from the committee. And I believe we have a couple of witnesses here that can further elaborate on the type of cases that they're seeing and why this change is prudent for the state.
Thank you for that testimony. Questions from the committee for the bill sponsor? Seeing none, first witness in favor of Senate Bill 1053, please come up.
Thank you, Senator Trent. Good afternoon, committee members. My name is Chuck Adamson. I serve as Civil Trials Chief, Section Chief at the Attorney General's Office. My section, we essentially litigate these cases for the state. We've got about 152 employment cases currently in my section. I would guess, I don't have the exact number, but about 80% of those are Missouri Human Rights Act cases. And, you know, the best way I can illustrate this is just by giving you an example. In September, I tried a case here in Cole County before a jury. That case involved 5 parties. It was filed in 2017. On the eve of trial, 2 of those parties were dismissed after being dragged through 8 years of litigation. These are all state defendants. 22 claims originally were filed. When the jury received it, they received 7 of those claims. Of those 7 claims, we prevailed on 6 of the 7 claims. The one claim we lost on, the jury returned a verdict of $50,000. The jury declined to award punitive damages, which means the jury found that there was not an evil motive or reckless indifference under the jury instruction. After that $50,000 verdict, the plaintiff's counsel asked for nearly $1 million in fees. Now, thankfully, a couple days ago, Judge Walker only awarded them $193,000 in fees. And we are very thankful for Judge Walker's order on that, but I can also say that he's an outlier. While we have gotten some traction here in Cole County on shaving some of these fees, courts throughout this state are routinely awarding these fee requests of plaintiffs' attorneys where they are starting out at $500, $600, $700 an hour fee requests, which then they ask for a 1.25 to 2.0 multiplier, which means you multiply that hourly rate, meaning they're asking for, in many cases, more than $1,000 in fees for, in some cases, reading emails, driving to court. They're doing other more complex things. I'm not disputing that. But this is all to say that these are windfalls for plaintiffs' attorneys. The statute, I will conclude my remarks here and just say the statute as it stands today provides, as Senator Trent pointed out, fees for prevailing parties, but it also says that state agencies are not permitted to get fees. And so we support this bill, the Attorney General's office does. We believe this would level the playing field. If we can't get fees, and frankly, we're not asking to get fees, I believe strongly in the Missouri Human Rights Act that complainants should be permitted to complain. They should be permitted to file lawsuits. They should be permitted to bring these in front of juries. This is important to have discrimination law, but what we should not have is windfall amounts for the plaintiff's attorneys, and this is a waiver of sovereign immunity. And we have car accident, dangerous conditions of property where we similarly have these waivers. There's a reason for that. As state agencies are accountable to bodies like this, to elected officials. So with that, subject to your questions, that concludes my remarks.
Thank you for testimony and questions for this witness. Seeing none, appreciate you being here. Make sure you fill out a witness form. I think I saw you drop one off. Just want to make sure. Next witness in favor, come on up.
Thank you.
Thank you, Mr. Chairman, members of the committee. Michael Gibbons, representing St. Charles County. We're very much in support of the concept of this bill. We would like to see it broadened to include all political subdivisions. Currently, this proposed statute limits it to public employers as defined in the legal expense fund. We have the local jurisdictions have the same problems that the previous witness just described. And what's happening is these public subdivisions are being essentially coerced into either a settlement position, not because they're afraid of the damage award in cases that they're choosing to defend, but because of the award of attorney's fees. And I don't think that's what this system should be about. So we're very much in support and happy to answer any questions.
Thank you for testimony. Questions for this witness? Seeing none. Next witness in favor. Senate Bill 1053.
Good afternoon, Mr. Chairman, members of the committee. My name is Rich Aubuchon. I'm here on behalf of the Missouri United School Insurance Council. We do insure the vast majority of the school districts in the state of Missouri. Like to make sure we were covered in this as well. I have personally seen offers for settlement come in at $1 million initially, when really what should happen is that person who is harmed and who is wronged people should say sorry. They should compensate them for the loss. They should get back to work as soon as possible, if at all possible. And what we see with a lot of this litigation is the first offer out the chute is $1 million because they're guaranteed to get attorney's fees under this. And it's a shame because a lot of these people really should go back to work. People should say they're sorry. People should be punished for doing these types of things to harm people. And instead what we see is protracted litigation, a lot of protection of everybody involved, and offers that are just unreasonable largely because the attorney's fees are guaranteed under the Missouri Human Rights Act. That's we're in support to make sure we were covered as well.
Thank you for that. I guess we got to leave and go to session at some point in time, but that's all right. Any questions for this witness? Seeing none, thank you for being here. Any further witnesses in support? Seeing none, yeah, no. I got this, brother. I got this. Witness in opposition, Senate Bill 1053, please come up.
Well, sorry. Thank you very much, Mr. Vice Chairman, members of the committee. My name is Arnie C., AC Denoff, State Public Advocate. I'm highly opposed to SB 1053. The Human Rights Act, Human Rights Commission, employee discrimination is a obligation to protect public employees from bad actors, from bad elected officials, which I'll give you an example here in St. Charles County. Our employees need protections from bad actors and people who discriminate, whether it's based on race, religion, a variety of different issues under the Missouri Human Rights Act. State, county, special districts, and all the political subdivisions can make life very tough and very rough and uncomfortable on public servants who serve our state political subdivisions in a variety of capacities and services. These are costs and legal fees that must be proved to a court and approved by a judge. So there's standards through the Missouri Supreme Court, promulgated rules. There's a code that says what's reasonable, what's not reasonable. This bill is protecting bad actors. I am running for county executive in St. Charles County, and I want to make sure that all 1,300 public employees are protected 100% from bad actors. We had an elected St. Charles County Election Authority Director who discriminated against 13 employees. The county had to pay out close to $2.5 million to settle discrimination lawsuits of employment and labor acts and violations of the Missouri Human Rights Commission. As a matter of fact, a woman who had bad knees and hips, there was no elevator at the Election Authority building, was forced to crawl up and down the stairs on the second floor of the Election Authority building, and she was not given the appropriate accommodations under Americans with Disabilities Act. This law is ludicrous, unethical, and wrong, and I will fight with every strength to make sure that this is defeated on the Senate floor. Please defeat Senate Bill 1053. Thank you, Mr. Vice Chairman.
Thank you for testimony. Any questions of this witness? Seeing none, next witness in opposition, please come on up.
Good afternoon, y'all. My name's Eric Plater. I'm a lawyer. I'm a civil rights lawyer actually in Kansas City.
Sir, can you please make sure the microphone's on, or at least get a little closer for the people that might be listening. Thank you.
Yeah, sorry. My name is Eric Plater. I'm a civil rights lawyer in Kansas City, and I have had a number of claims against the state where the legal expense fund is paid. And first of all, it's actually not true that the attorney's fees are guaranteed. That's a lie. That is absolutely a lie. It's not true. And when lawyers win and they're the prevailing party, they submit a fee request to the court and a judge reviews it. And just like you heard from the first person that testified, judges routinely cut those down. But the fact of the matter is the work has to be done. And the state is the largest employer of public people in the state, of course. The Missouri Department of Corrections is a perfect example of that. The problem is that this is couched and presented to you as though like the plaintiff's lawyers have a reason to increase the fee bills because of the fee shifting provision. I can only tell you about my experience. I've tried 13 cases where the legal expense fund was funding the defense. In 12 of those 13 cases, do you know what the offer of settlement was? Zero. And in the one case that an offer was made, the offer was $50,000. The collective verdicts in those 13 cases were over $19 million. Nothing to do with attorney's fees, nothing to do with us putting the work, overbilling or anything like that. We offered in those cases, we made demands in those cases of less than $5 million collectively. And someone at the state, someone is saying, you know what, we're not offering these people a penny. And now they want to complain that it costs money to litigate. I mean, think about that. They offered $50,000 collectively, and the jury, the people of this state who heard those cases said over $19 million. That's not on us. But it takes work to do that, and the state should not be exempt from any other employer in the state. I'm happy to take any questions.
All right, sir, thank you for your testimony. Questions for this witness? Seeing none, thank you. Any witnesses for any further witness opposition? Seeing none. Any information purpose? Seeing none. No further business come from the body. Make motion to adjourn. Seeing a second. All in favor say aye. Aye. We're adjourned.